Hi, I'm Tom Popinski, and I'm one of the partners at Burgess Law, actually one of the guys that started it.
I'm Nathan Nelson. I'm another partner at Burgess Law.
And one of the guys that started it.
Yes. So, we want to talk about estate planning today. And estate planning is a way for you to control your property while you're alive and well, while also providing for your loved ones and providing for yourself if you become disabled. You get to give what you have to who you want, the way you want to give it to them, and when you want to.
The problem with traditional estate planning is you know estate plans that are going on in the background and you don't even realize it. Like, for example, you might have an IRA and you have a beneficiary on your IRA and you have one of your children on that as a beneficiary and you don't realize that they're actually going to be the ones that get it to the exclusion of the other children that you have. Or you might have joint tenancy on your property where you own your house with somebody else, one of your other children. That's going to end up being theirs, and that's a form of estate plan. You're disposing of your properties, and it might have some unintended consequences. Same thing can happen with 401ks, life insurance policies. And so what we try to do is try to bring all of these plans in one format and put it into one particular bucket. So everything is being distributed the way you want to have it distributed.
So if you think about your planning, try to put some priorities to it. With one being yourself. You want to take care of yourself, then your family.
The self part is probably the most important.
Probably the most important. We want to preserve your wealth and then ideally expand your wealth. And then at the top, if you think of it as a pyramid, we try to save taxes where we can.
And that saving taxes is the last piece that happens.
So the problems with most estate planning is it doesn't let you give what you want to who you want, the way you want to give it to them, and when you want it. And most estate planning doesn't avoid probate. Probate is very public. It ends up causing some delays in the transition of your assets. And there's a cost associated with probate. And also, if you're going through probate, you're not providing for your own disability in common estate planning techniques. So when you're disabled, you're stuck with just your insurance, and your current wealth doesn't benefit you.
On that cost piece, sometimes people talk about, they don't want to take the time to spend the money to do their estate planning, but the cost piece actually is less expensive if you do it in advance than if you wait through the probate process. The probate process is probably at least 2.5 times more expensive than traditional estate planning. The other thing that the way we do estate planning, as opposed to just having a straight out will or not having an estate plan at all, is we also provide for things that happen during your lifetime. We call it living probate. The court system calls it a guardianship or a conservatorship, and it's very public. It's if you want to take control. For instance, if your father is experiencing some dementia and you want to take control of their affairs, if he doesn't have an estate plan like the way we develop it, then you actually have to go to court, and you have to, in an open courtroom, explain to a judge that your father, who you love and cherish and have spent your lifetime admiring, is delusional and unable to take care of himself, and you're there to do that. So the way we do it, we let the father in charge before he experiences any of those issues, conservatorship and guardianship proceedings. The traditional estate planning technique is with a will. It's not an interstate planning tool, which means that a will is just effective for the state that you're in and the state that it's derived from. You have to actually probate it in separate states. It has to be stored properly. It has to be available. It doesn't provide for what happens in the event that you become disabled or you're living probate issues. We have to prove that it's actually a valid will. The probate process can be complex, it's public, it's time consuming, it's expensive, and it really puts the real control of what happens to your estate in the hands of a judge, and you don't even know who they are.
So one of the techniques we use is revocable living trust. Now that's a trust which has a fiduciary relationship with respect to any of the property that's put into it. It subjects the person who's running the trust, the trustee, to some equitable duties to deal with the property. The trust is always for the benefit of another person, and it arises because we intend to create it. It's not done by accident. It's formally done because we're intending to create a trust. And one of the benefits, or there's many benefits to revocable living trust. One is plans for your disability. We talked about what happens if you get sick. With a trust, your wealth actually helps provide for your own care during your illness. It allows you to provide for loved ones if they become ill or disabled. A trust can contain your instructions about how you want your assets to be distributed upon your passing. And where a trust is different than probate, we're talking about probate is very public. A trust is private, it's confidential. The public doesn't know about it, doesn't know what assets. So you don't have to worry about the community knowing how you're distributing your assets. And it allows you to reflect your hopes, your values, your dreams, and pass that on to loved ones. And a great thing about a trust, it's valid in every state. So it's not limited to just Minnesota. So if a trust is properly funded, it avoids probate. It allows your affairs to have some continuous activity. So if you have property, it's a seamless transition to the next person who can run those properties, for example.
You know, if you're a privately held business owner or a real estate investor, and we deal with those issues a lot, it really creates a smooth transition without any sort of judicial intervention with regard to your business affairs. So, if you become incapacitated or, you're in a coma or something like that, and you need to have the business operations attended to, or a contract signed, or you have a big deal that's going to close inside your business, and you need somebody to address it, or a lease opportunity with one of your real estate investments, and that person's not going to likely wait 3 months for the judge to go through and determine whether or not that lease is a fair and reasonable lease with a fair and reasonable term. See, the judge is concerned, okay, I have no idea what this person wants. And now somebody that isn't this person is coming here and they want to bind this incapacitated person to a business deal that this person has never spoke about or talked to me. And so I've got to make sure that that's fair and reasonable, because that person's going to come out of a coma. That person might recover from the dementia or something like that. And that they have to live with the deal that I give by virtue of this court proceeding. And so they're very concerned about making sure they're doing the right thing. And so you have this judge who might not know anything about commercial real estate, try to understand if $12 net lease is a fair rate. And they might not know what a net lease is. They might have to actually go figure out, okay, what is the difference between $12 net and $12 gross? And how is that going to affect them?
The trust is really difficult to attack, so it really prevents family members, creditors from attacking you, because it's so difficult. And it provides guidelines for the distribution of your assets and for investments to make during your lifetime in case you're incapacitated.
So here's how the trust works. You're the trust maker. You're the grantor. You say it's a contract with yourself, essentially. And you say, I'm going to take all my assets, I'm going to plop them into this trust. You can change them whenever you want. It's a revocable trust. It's not binding to you. You can always change your mind. You become the trustee. And through that process, you're determining, okay, what do I want to have happen in the event that I'm disabled? How am I going to define disability? How's that going to work? You also talk about what's going to happen when you die. How do I want the assets to go? How do I want my children to be provided for? But you're in charge. It's your decision. We talked about pyramid before. We also have a triangle. And the triangle deals with how we're going to plan and different roles through the planning stages. During our lifetime, we're going to have most of the decisions ourselves. We're going to reserve for ourselves. But if one of us becomes disabled or one of us dies, in terms of you or your spouse, then you're going to have separate decisions that you have to make. Sometimes you decide, I'm going to have one person make all those decisions. But the person that makes the decision on distributions, like who to pay and when to pay, is sometimes not the best person to make decisions on what should I invest my money on. So you can actually have one person making investment decisions, we call it an investment trustee, and you can have another person making decisions on distributions, and we call it a distribution trustee. And so we might want to have that distribution trustee be somebody that's close to us, or we might want it to be a professional like an accountant or something like that. Let's say we use an accountant, but you want to make sure that that accountant is being watched and looked at. Now comes the third role, which is a trust protector. And the trust protector is a concept that's borrowed from offshore asset protection planning, or offshore trusts. And we take that trust protector and we put it right into the driver's seat of approving distributions or approving investments or both. So if you have your accountant making that decision, you say, well, I want to make sure my accountant just doesn't write himself a big check and say, hey, this is for free for my fees. So that trust protector has co-signing responsibility. No check can be cut unless both of them sign. And that trust protector is watching over what the accountant's doing. That trust protector might be your mother, might be your brother, might be your best friend, but it's somebody that's likely not going to be absconding with you or engaging in some scheme with an independent third party that are fraudulent.
So with the trust and with estate planning, one of the things we try to do is pass on their family values. So if it's important for you that children receive an advanced degree, we can put that into the trust. If you want to use those funds and have some reserved for a child or a loved one to buy a residence, we can do that. We can use funds to purchase a business or to start a business.
One of my favorite ones on that day was, I had a client that just loved entrepreneurship. And they said, you know, if my kid can, it's your client too, if my kid can demonstrate to a CPA that this is a good business, any CPA, they didn't care who the CPA was, they can demonstrate to a CPA that this is a good business to buy, and it's bankable by 75%, which means that if the purchase price is $1 million, an independent bank has to come in and loan $750,000. Then he directs his distribution trustee to let him have the $250,000 down payment that he needs to buy that business. That was one of our cool ones. Somebody that really loved entrepreneurship.
It was pretty cool. We can put in some restrictions that income is only distributed if the beneficiary earns a certain level. We put in restrictions that income is only distributed if it corresponds with some type of charitable distribution or charitable deduction. And you can force your children or loved ones to practice making investments by using a co-trustee that has to work with them early on to make those investments. Because one of the problems is, if suddenly your child has an asset that they've never had before, how are they going to use it if they haven't necessarily had practice yet? So you can actually put some pieces in place that gives them a ramp-up period to train to take over their own investment activities.
You know, the typical estate planning that happens in Minnesota, which is different than how we do it, typical estate planning is very one-dimensional. It just sets out assets when somebody attains the age of 20. This is my favorite. Somebody's 25. My favorite thing that they do that they shouldn't do. When somebody's 25, they get a third of the wealth. When somebody's 30, they get a third of the wealth. When somebody's 35, they get the last third. So when they're 35, they've got all the wealth passed on. This is probably 50% of the estate plans in Minnesota. 35 years old. When I was 35 years old, don't give me that money because it wouldn't be here now when I'm in my late 40s. So it is an opportunity to be more than just one-dimensional and try to throw the money at the kids at various times. You can be two-dimensional in your approach. You can make provisions for your spouse to care for your spouse. You can make provisions for your children to care for your children. We can double the credit shelter exemption. That's a big piece. And the credit shelter has gone from it's very over the last 10 years. Right now it's 5.4 million per person, but we can double that to 10.8. But here's the thing: most people don't have estates like that, and they say, hey, listen, I don't really need that type of two-dimensional planning for the credit shelter exemption, but in Minnesota you do, because everything over $1 million is subjected to a tax of about 8%, and with a simple estate planning trick, we can double it. And and it's widely accepted. If you talk to any estate planning attorney, they would explain it, and probably 75% of all attorneys would be able to explain how the credit shelter exemption works, but you gotta do it. You can't just sit back and rely on state statute. And it's, some people say, well, geez, I don't even have $1 million estate. I don't have anything to worry about. But the way the government defines your estate, they say, no, it's your net worth plus the life insurance proceeds, even if the life insurance is paid out to beneficiaries. So it's pretty easy to get to that credit level. The part that I really enjoy about actual distributions I mentioned 25, 30, and 35. We ignore that. We try to use the values-based planning that Nate was talking about. We want to take our values, the client's values, your values, and we want you to perpetuate them on to the next generation. We want you to reach out from the great beyond and control the lives of the ones you love. Kind of kidding. And give them opportunities and access to your cash. But we don't want anybody else to have access to that cash. So the way that we do it, unlike just throwing it up on you at 35 and now you're stuck with all this money, your ex-spouse can access it, your creditors can access it because it's just common money you put in your common pool. We like the Rockefeller way or the Kennedy way, where we're putting them in asset protection trusts. There's spendthrift trust, widely recognized in Minnesota, widely recognized in most jurisdictions, where creditors can't access it, not even ex-spouses.